Nadimul Haque.
Sir, today I stand before the House to discuss the real estate bill. In my opinion, sir, the real estate sector constitutes the most important building block of a nation as it provides infrastructure and housing for better life of all the people residing in the country. However, sir, in our country, a specific law stating the duties and rights of buyers and the promoters involved in the real estate sector has been largely left unaddressed. Though the consumer in our country could avail the remedies available under the civil, criminal, and consumer law against these players, but these remedies are not broad enough to address all the issues and concerns of the buyers of the real estate. This situation has led to gross mismanagement and unprofessionalism in the field of real estate, wherein project developers indulge in tactics of deliberate delays and other wrongdoings. In order to address these issues, the Real Estate Regulation and Development Bill was introduced in the Rajya Sabha in 2013, sir. It was later on referred to the Standing Committee and then to the Select Committee, and both these committees have submitted their report. The bill, as it stands today, regulates transactions between buyers and promoters of residential real estate projects. It establishes state-level regulatory authorities called the RERAs. Sir, these promoters need to be registered with the RERAs, and they cannot book or offer these projects for sale without registering. Real estate agents dealing in these projects also need to register with the RERAs. On registration, the promoter must upload the detail of the projects on their website. Sir, the bill also penalizes. In case the promoter fails to register the property, he may be penalized up to 10% of the estimated cost of the project. Failure to do this, despite orders issued by the RERA, will lead to imprisonment for up to 3 years. He will have to also pay 5% of the estimated cost of the projects if he violates any of the provisions of the Act. Sir, however, sir, there are some grey areas in this bill which I would like to point out clause-wise. In the clause 3.2a, the registration of real estate project of the original bill mandated registration was not necessary where the area of land proposed to be developed does not exceed 1,000 square meters or the number of apartments proposed to be developed does not exceed 12. Sir, the Select Committee reduced this to 500 square meters and 8 apartments, and power was given to the appropriate governments to reduce the threshold from 500 meters and 8 apartments. So it is pertinent to mention that if this clause is passed, then it may lead to the exclusion of middle class or poor class who are vulnerable to a higher rate from the promoters. So secondly, the clause 4.2id, the original bill puts a positive obligation on the promoter to put 50% funds as notified in a separate bank account for construction work. Sir, it does not take into account the fact that there might be different situation in different states, wherein the cost of land may be higher than the cost of construction. Sir, clause 5.2 in the original bill stated that if the application of the promoter to register is not accepted or rejected in 15 days, then the project shall be deemed to be registered. The committee recommended that this period be extended to 30 days. Sir, I have to say that the said clause can be subject to abuse, as there might be a lot of instances that the authorities might not be able to register a promoter project due to overburden of work. Sir, clause 7.1a states the revocation of registration. The original bill included willful default on the part of the promoter to do anything under the Act will lead to revocation of the registration. The panel had recommended that the word willful be deleted from the definition. However, sir, the recommendation of the panel to delete willful is meritorious. At the same time, the recommendation tilts the balance in favor of the buyer and against the promoter. The promoter is now strictly liable under the bill for any default. By deleting the word willful from the definition, the promoter is now liable also in a case where he may have acted in good faith. The aforesaid recommendation would equally establish a balance between the right of the buyer as well as that of an honest promoter. Lastly, sir, this bill does not include anything about the sanctioning authorities. For example, even if a project is completed and there's a delay in seeking completion certificate from the local authority, or there's a delay in obtaining electrical and water connections, the project cannot be offered for possession to the buyers on time. For this purpose, sir, rules and recommendation to the sanctioning authorities has to be incorporated in this bill. With this, sir, I rest my case supporting the bill. Thank you, sir.
very much.